How's it going, everybody? Welcome back to 2A News Now. And as always, I appreciate everybody that takes time to watch my videos. Most of you by now know that the Supreme Court denied to hear cases concerning assault weapons bans and high-capacity magazine bans, which is ridiculous. It's time for them to take up these cases. And like a lot of people are saying today, the Supreme Court has kicked the can down the road again, and they could possibly take it up later this year. But most likely, I'm guessing it's going to be sometime next year. But even though this is very disappointing, there are some good signs that they will take up these cases. In part of Judge Kavanaugh's statement about their decision today, he said it doesn't mean the court believes the Fourth Circuit got it right in upholding the ban, but also since they didn't take up the case and decide in favor of people's Second Amendment rights. There are a lot of people in certain states that are not able to exercise their Second Amendment rights because of these assault weapons bans and these high-capacity magazine bans. And Judge Clarence Thomas wrote his dissent about the court not taking up these cases. And even though at the end he said he respectfully dissents, what I'm going to read to you now shows that Judge Clarence Thomas is just as pissed off as we are that the Supreme Court didn't take up these cases. And the Supreme Court has avoided deciding these cases for up to a decade now. And that's why I said earlier, it's time for them to do so. And the court said they could wait a term or two before they take up these cases. And what Justice Clarence Thomas is going to say in his dissent, that the Fourth Circuit Court made errors in upholding Maryland's ban on semi-automatic rifles and shotguns that are commonly used all over the country. And Justice Thomas also said that the Fourth Circuit Court also messed up when it said AR-15s aren't protected by the Second Amendment because somehow they believe that AR-15s are dangerous and unusual weapons. They've lost their freaking minds. So let's take a look at Judge Clarence Thomas's dissent. It's a little bit lengthy, but it's definitely a good read. The Fourth Circuit separately erred in determining that AR-15s fall within the historic exemption for dangerous and unusual weapons. A weapon may not be banned under this principle unless it's both dangerous and unusual. Weapons in common use today for self-defense are fully protected under Bruin. The Fourth Circuit nevertheless eschewed any inquiry into the commonality of AR-15s and the purposes for which they are used, which it dismissed as an ill-conceived popularity test. Instead, the court performed its own independent investigation of AR-15s, utility for self-defense, examining their military origin, firepower, and muzzle velocity, among other features. Our Constitution allows American people, not the government, to decide which weapons are useful for self-defense. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all under Heller. In line with that principle, and with the tradition of prohibiting only dangerous and unusual weapons, we have never relied on our own assessment of how useful an arm is before deeming it protected. In Heller, we found handguns protected because that class of arms is overwhelmingly chosen by American society for the lawful purpose of self-defense. We recognize that stun guns were protected arms solely because they were not unusual, without addressing the state's court holding that stun guns were dangerous. And in Bruin, we again found handguns protected solely because they are in common use today for self-defense, without inquiring whether they are in fact useful for that purpose. An AR-15 and other type style firearms are one of the most commonly used long guns in the United States, and for the most part, people purchase them for lawful purposes, including self-defense, home defense. They're used for hunting. They're used for sporting purposes. But yet Judge Clarence Thomas isn't finished with his dissent. This is what else he had to say. Recently amended regulations of the ATF provide that a firearm under the Gun Control Act includes objects that may readily be completed, assembled, restored, or otherwise converted to a working firearm. In Vanderstock, the court refused to hold that definition unlawful, reasoning that an artifact noun that is a word for a thing created by humans may refer to unfinished objects, and thus the weapon parts kits are as regulated as the firearms they might eventually become. But every single AR-15 can be converted into a machine gun using cheap, flimsy pieces of metal, including a coat hanger. It seems that ATF could at any time declare AR-15s to be machine guns prohibited by federal law. Thus, on the court's logic, until we resolve whether the Second Amendment forecloses that possibility, law-abiding AR-15 owners must rely on the goodwill of a federal agency to retain their means of self-defense. That is no constitutional guarantee at all. So if we go by Clarence Thomas's dissent, he's definitely on board taking up these cases, as well as what I mentioned that Judge Kavanaugh said. And Judge Kavanaugh also said that Judge Gorsuch and Alito would have granted cert, meaning they were all for hearing those cases. So if you just go by simple math, that's 4 votes for overturning assault weapons bans, making them unconstitutional. Now there still are a couple of judges that are on the fence, that they chose not to hear these cases right now. And like I said, kick the can down the road a little bit more, because they might be able to persuade Justice Amy Coney Barrett and Chief Justice John Roberts to take up these cases as well, to leave these bans in place for another term or 2. But on the other hand, stops millions of people from exercising their Second Amendment rights. The Second Amendment isn't a second-class right, and the Supreme Court has even said so. But yet they continue to kick the can down the road. And today they denied hearing these assault weapons ban cases. And these cases concern people exercising their Second Amendment rights and not being able to own one of the most popular firearms in the United States. I sure am glad that we have Clarence Thomas on our side. And like I said earlier, they said they're delaying this because they're trying to get more justices on board. Now the thing is, do we really believe that? Do you guys believe that? Let me know in the comment section. But also, like I said earlier, it's time for the Supreme Court of the United States to take up these assault weapons ban cases and these magazine ban cases and do the right thing, because we have a Second Amendment right to keep and bear arms. And they need to take up these cases and uphold our Second Amendment rights. And also, I just want to say I appreciate everybody that supports the channel. Not only those who watch my videos every time I post, but also the ones after watching the videos who take just a little bit of their time to like, share, and subscribe and hit those post notifications. I really do appreciate it, and it helps the channel out and it helps it continue to grow. And I invite all of you to come back and watch my next video.